Let's file this under laws that I would like to see changed, okay? In case you're new here, I'm Jonathan Noble, divorce and family law attorney. Let's get into this one, all right? Laws I'd like to see changed. You know, I've seen hundreds of domestic violence protection from abuse cases, and the standard in order to get a case granted is you have to prove by a preponderance of the evidence that the defendant attempted to cause serious bodily injury, imminent serious bodily injury, or you placed another in reasonable fear of imminent serious bodily injury, or you inflict false imprisonment upon someone. And the person, there has to be a connection, at least in Pennsylvania, between the two people, whether you were formerly household members or relatives or intimate sexual partners, or you were persons who shared the same biological parenthood. In other words, like your baby mama or baby daddy. So the standard to prove it is by a preponderance of the evidence. It's not like a criminal case where it has to be beyond a reasonable doubt. Now, here's the law that I would like changed, because I've seen hundreds of these cases, and many of them are clearly not going to get granted in front of a judge because of a number of reasons. But I saw a case recently where a 50-something-year-old woman filed a case against a 30-something-year-old neighbor, okay? So they don't share parentage. They were never household members together. But the 50-something-year-old woman alleged in her complaint that about 10 years ago, they were intimate partners. And just by looking at the two of them, and I had a chance to speak to both of them, there's no way that they had anything to do with each other. But the 50-year-old something was vindictive and had nothing better to do. So she filed, and this was not her first filing against her neighbor, under protection from abuse. As far as I could discern, the 30-something wanted to have nothing to do with this lady. She was just not interested in interacting with her whatsoever. So the case went in front of a judge, and it got thrown out. It was not granted. It wasn't even close. And here's the law that I would like changed. The woman, the younger woman, the defendant in this case, had to take off from work a whole day in order to wait for her case to be called. Whereas the plaintiff, this 50-something-year-old woman, wasn't working. She was collecting money through the state. Unbelievable. I think the law should read that if you file something and it has no merit, I'm not saying that it's not granted, but if it just has zero merit and it doesn't get granted, there should be a box the judge can check that says that the plaintiff who brought this bogus protection from abuse domestic violence claim against the defendant has to reimburse the defendant all their reasonable costs, including lost wages for the day. And if they hired an attorney, they need to pay the other person's attorney's fees. I've just seen too many cases where someone will file a protection from abuse and the temporary may or may not even be granted, and they go to a final hearing. And the poor defendant they had nothing, they don't want anything to do with this person. None of the allegations are true. There's no evidence they're true. And the case just gets dismissed. And the plaintiff goes and files again against the same person. So there needs to be a mechanism in place, at least in the jurisdictions I'm familiar with, that deter these bogus protection from abuse filings. They are absolutely unacceptable, but the court's hands are tied because there's not much you could do about it. Now, the defendant in the case I just described could go to the DA and ask them to prosecute the plaintiff because she lied under oath. She signed the complaint saying that under the penalty of perjury, everything was true. And the plaintiff in this case clearly was not being honest under oath in court, at least through my lens, okay? I wasn't a judge, but something should be done. I don't know if any jurisdictions allow the defendant to recoup their costs at attorney's fees if there's a real bogus protection from abuse filing. Now, some of the cases are a lot closer than the one I just described, but if there's one that just has no merit, you ought to reimburse or compensate the defendant and stop these plaintiffs from filing multiple bogus protection from abuse claims. Not fair, not fair. That's my rant for the day. Leave a comment. Share this with someone who's tangled up or potentially tangled up with someone who's using the judicial system as a weapon unfairly. It's unbelievable but true. Be careful out there.